Could you define beyond the combat situation scenario what you mean by uniquely federal interests?
Well, I agree with much of the answer that my friend just gave you to that, Justice Thomas, that we start with the Constitution structure here, and we have a list at the top of page 12 of our brief of other areas where the court has found there to be uniquely federal interests. They include things like foreign affairs, rules implementing federal loan programs, civil immunity of federal officials. They're areas where the Constitution and the statutes and the laws of the United States have made it clear that this is an area of exclusive federal interest. And I think that that's clearest in this context because federal powers are at their zenith.
Let's say I grant you the combat. Beyond that, how do we define it? Because this isn't going. Once we say that this uniquely federal interest carries the day, why wouldn't someone from, say, our military bases in San Diego or in Norfolk, Virginia, who's servicing aircraft carriers or nuclear subs, why isn't that unique?
Well, I think that the states would have more interest in what's going on in California than they do in what's going on in Bagram. But we're not asking the court to invent a new type of preemption here. We think that when Boyle talked about uniquely federal interests, that's a concept that this court used in Sabatino to say the active state doctrine is an area of uniquely federal interest. And the way the court determined that it was by looking to the Constitution, which it said didn't dictate the content of the active state doctrine. It looked to statutes that said that they provided indirect support for the active state doctrine, but it said the very idea that we have U.S. courts questioning the acts of foreign territories foreign sovereigns in their territory is something that is of uniquely interested to the federal
Boyle
government.
didn't say as much. You're making Boyle do a lot of work that I didn't read into Boyle.
I think Boyle is standing on a line of case law that talks about uniquely federal interests as being a source of preemption, that this court has continued to repeat that category as being out there as recently as Casarir and Rodriguez, where the court acknowledged that this is there. And I think this is an easy case for determining that it's a uniquely federal interest because of both halves. The federal power is at its zenith because of the way the Constitution has vested war powers in the federal government, and state powers are at their nadir because it has expressly divested states of those types of powers.
Counsel,